Good afternoon and welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to start a series of where we cover landmines in civil litigation. There are so many of them. I know years and years ago I did an article on the 10, landmines, but there are always new ones coming up, and I always run into them when I have, working on my cases. So as I come across these, I think it's good to kind of present them, through this forum. So we're going to talk about, and I don't know how many people are aware of this one particular rule of civil procedure. It's involuntary dismissal, and that is another procedural landmine in civil litigation. And we're talking about rule of civil procedure. It's 1.420B, and I want to quote that. It's a good one to know for litigators. Any party may move for dismissal of an action or any claim against that party for failure of an adverse party to comply with these rules or any order of the court. Have your notice of hearing. And after a party seeking affirmative relief in an action tried by court without a jury has completed the presentation of evidence, any other party may move for dismissal on the ground that on the facts and law the party seeking affirmative relief has shown no right to relief without waiving the right to offer evidence if the motion is not granted. So the court, as trier of facts, may then determine them and render judgment against the party seeking affirmative relief, or may decline to render judgment until the close of all the evidence. And so interesting. So unless the court in its order for dismissal otherwise specifies a dismissal under this subdivision and any dismissal not provided for in this rule, other than a dismissal for lack of jurisdiction or for improper venue or for lack of an indispensable party, operates as an adjudication on the merits. Okay, so you can be in a non-jury trial, a bench trial, and a party can move for an involuntary dismissal for a lot of reasons, even if for non-compliance with discovery, right? And this can happen a lot in foreclosure cases too. And the court may agree and grant the motion for involuntary dismissal. So the important thing is in that case, that dismissal operates as an adjudication on the merits. All right, what does that mean? You really have all sorts of implications here, and people don't realize it. So you want to be aware of this ahead of time. Okay. You can have jurisdiction issues, subject matter jurisdiction issues. You can also have res judicata, collateral estoppel issues arise. I'm going to show you how that works. There's a case that I came across, and it's fascinating. I mean, we try to cover, of course, recent cases, but the cases are out there for a reason, right? So we try to pick really important cases, I think, that affect the practice. There's a case called Franklin v. Bank of America, 202 7th 3rd 923. It's FLA First DCA 2016 case. And I was just fascinated with this case. That case you had a foreclosure action. Mortgagee brought a foreclosure action. The trial court entered a summary final judgment of foreclosure more than a year after the action was dismissed based on the mortgagee's failure to comply with the discovery order. The first district in that case held that the foreclosure judgment was a nullity because the trial court lost subject matter jurisdiction following a dismissal without prejudice. So it's crazy. I mean, you get all that work, you get your summary foreclosure judgment, and appellate court is going to call it a nullity. And what happened in that case was you had, and I'm trying to think of facts. Yeah, the court held that the court lost subject matter jurisdiction. I'm going right to the case over the foreclosure action, and thus, the subsequent entry of summary judgment of foreclosure was a nullity. The trial court had previously entered the order dismissing the action without prejudice. Okay, but that order did not include the terms, quote, with leave to amend, and no action was taken in the case for 70 days. And during which span both the time to move for rehearing and the time to appeal had expired. So, and I believe what happened is they went and they filed an amended complaint in the case later on. It was almost a year later, long after that order. But what the court said, they reasoned after a final appealable order is entered by the trial court, and so that order, uh, without prejudice, right? I'm dismissing it without prejudice. That's a final appealable order. It's dismissing the case. Um, the court held the trial court's jurisdiction to enter additional rulings decreases as the time progresses. So during this time, a motion for rehearing can be filed, and the trial court is said to retain continuing jurisdiction over the case. But if, however, the rehearing mechanism uh, is not triggered by service of a timely motion, then the court loses jurisdiction of the case at the expiration of the time for filing a petition for rehearing. Fascinating. And so, what happened in that case is it just kind of got by everybody. They had gone ahead and I guess plaintiff went and tried to do the amended uh, complaint and went ahead and got their summary judgment foreclosure. And the mortgagor appealed. The appellate court said, no, you've lost subject matter jurisdiction. The judgment is a nullity. That's the Franklin case. There's another case. Now, that one was out of the first. There's another case out of the fourth, Magloire, Magloire, v. Bank of New York. And that's 147 Southern 3rd, 594. And that is a 4th District, 2014. And same thing basically happened. And the appellate court said, trial court lacks subject matter jurisdiction to grant motion for summary judgment. And as everybody knows, you never waive subject matter jurisdiction. Personal jurisdiction, yes. Subject matter, if you didn't raise it below, you don't waive it. You can raise it at the appellate level for the first time. Magloire even went further and said the granting of a motion for summary judgment could not be justified as exercise of court's equitable jurisdiction. So they were trying to get around the subject matter jurisdiction issue. So that's a shorter opinion, but fascinating law on that. So I would recommend everyone read that. And that's the law on involuntary dismissal. And that is definitely a landmine you want to watch out for. Again, any questions, feel free to give us a call. I think that's an important issue and one that all litigants should be aware of. Thank you again for your time.